Okay, we all know you as realtors, if you're about to take a listing appointment, the last thing you want to find out is that that property is going to need to go through probate. Now, if that property is not vested in a trust, or if there's nobody still around that has right of survivorship on that property, you can pretty much assume that you will need to deal with probate. Prior to April 1st, 2025, for a property to avoid going through full probate when the property owners have passed away, that property would need to be valued at $184,500 or less to qualify for small estates probate. But really, when was the last time we've seen properties valued at under $200,000? Not often. Now, as of April 1st, 2025, there's a new Assembly Bill 2016, which is pretty much a game changer. The threshold to avoid a full probate has increased from $184,500 to $750,000. We all know we want to avoid probate because it gets dragged out in court, takes forever, and it's very expensive in legal fees. Now, through Assembly Bill 2016, the decedent's family can skip the long, expensive probate proceedings, take ownership of the property, and put the property on the market if that's their desire. Don't quote me on this, but from what I've read, this can take weeks versus a full probate, which could take months or even years. So as we know, in California, and especially Southern California, most properties we come across are valued over $750,000. So this won't work for them. But as you can see on this chart that shows the median home sales prices by county, this will still benefit many families. So now let's get into the requirements. But first, I just have to say I'm not an attorney. I'm not giving legal advice. This bill is also very new as of the date that I'm shooting this video. So there's still some unanswered questions and forms that need to be updated. So how do you take advantage of this new law? First of all, the decedent must have passed away on or after April 1st, 2025. And the gross value of the estate at the time of death cannot exceed $750,000. And that value is determined by a court-appointed referee or appraiser. Also, the property must have been the decedent's primary residence. Now, many attorneys think this could cause some ambiguity in trying to determine what qualifies as primary residence, especially when you're dealing with elders that might have been living with family or living at a care facility. But as we get through this and some of these transactions close, we will learn more as we go. So now, instead of going through the full probate, the claimant simply has to fill out and submit a petition to the court. This petition is called a petition to determine succession to real property. Currently, this form is the DE-310. However, a new updated version is not available yet. This form includes details about the decedent, the residence, and the claimant's relationship to the decedent. Additionally, they must wait 40 days after the decedent's death before they can submit this petition. This just gives them extra time to gather necessary documents and to ensure no surprises like a hidden will popping up. Lastly, you must notify all heirs, beneficiaries, and interested parties. Now, this is where it could get a little sticky. There might be disputes between siblings, whether they want to keep the property, sell the property, or whatever they want to do with the property. But at least it increases the transparency, but of course, it can also bring up disputes between siblings. And this notice must be served at least 15 days prior to the court hearing. Once you have that petition approved and signed by the court, you will need to get a certified copy of that order. You will need to get that certified copy recorded with the county recorder, or if we're in the middle of a sale transaction, you can just get that certified copy sent to the title department and they will record it concurrently at the closing with that sale. So I know this is a lot to take in. If you have any questions, I'm here to help. Just reach out. Have a blessed day. Talk to you soon.